It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like, how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my co-host who has gone bananas, Brett.
Hi, Alice. See, no one will understand that joke because they don't know about ooples and Banu-News.
They need to listen to the outtakes because, guys, we've been recording for a few minutes at this point, and out of nowhere, Brett just starts singing Apples and Bananas, the song for small children.
Great song.
And I think he's lost it. I think he's actually lost it, but it's my fault because I delayed our recording until like 10 p.m. tonight because life, you know.
Life.
That's
true.
Life gets in the way of our podcast life.
And I would have just said, let's just record tomorrow, but this is a breaking news podcast tonight. So we had to do it.
We had to do it because around, let's see, mid-afternoon today, my phone started blowing up. I was trying to, do the thing where you put your phone to the side so you can focus on your work. I could not because our phones were exploding with people texting us about none other than Adnan Syed. Yes, today was the day that Adnan was really in the news, and there is a lot to talk about. We thought we were going to talk about one thing, but then the courts did something else today. So we will try to fill you in on all of it and try to give some reasoning to a very bizarre turn of events.
And that's one of the reasons we did this podcast, is to be able to do exactly this. On our other podcast, we're in the middle of Ellen Greenberg. It's not as if we would have stopped that to do this, but because we have this podcast, we're able to respond to these breaking things. And I do want to say, I know there's a lot of people out there who believe deeply that Adnan is innocent of the murder of Hae Min Lee and have been working diligently to reach this conclusion. So I do want to say congratulations to you. I know this is a day of celebration for you, and that will probably be the last positive thing we say about what happened today as a part of this. But like I said, I know this is quite an accomplishment, so congratulations to you on that.
Well, Brett, what are we talking about? So you all know Adnan Syed was first made known to households around the world because of the Serial podcast in 2014? It's been almost 8 years, I think, that this story was first told, and it was that he was convicted for the murder of Hae Min Lee. And he has been in prison since he was convicted many years ago. But since the Serial podcast came out, there was a lot of flurry of activity around basically people who wanted to question his conviction. And we have never covered Adnan's story or Hae Min Lee's story on the Prosecutor's podcast or other podcasts, but a lot of legal developments have happened with, first, a motion filed by none other than the state to, surprisingly, vacate his conviction. So not the defense, but the state. Let's talk about how we got there to begin with.
Yeah, and a couple things. Number one, we have never covered this in depth. This podcast is not about whether or not Adnan Syed is guilty or innocent of this murder. We're not going to get into that today. We'll talk about some of the evidence against him, But we've never done a deep dive into it. We haven't really looked into it. I can't say for certain whether he is or he isn't. A lot of you listen to Serial. You developed your own views. When I listened to Serial, I came away thinking he probably was guilty. I think in the years since Serial came out, there are some things that Serial may have gotten wrong. He gets a lot of criticism. Undeservedly, I'll say this. Adnan Syed would not be free today were it not for Serial. So those of you who criticize Serial, give them a little bit of credit. They might have gotten some things wrong, and that might lead some people to think he's guilty, but they definitely got the ball rolling on this, and I don't think there's any way that we would have gotten here without that. So this is another example of a podcast having a real effect, and obviously we probably wouldn't be here either if it weren't for Serial. Serial did a lot to bring sort of podcasting into the mainstream, but as Alice said, there have been a lot of filings over the years since Serial came out. A lot of the stuff that Serial raised and some other things, there was a documentary on HBO called The Case Against Adnan Syed, which was the opposite of that. It was very pro Adnan Syed, but it was breaking down the case against him. And there's been filings about that related to whether or not his counsel was ineffective. We covered that in an earlier episode related to possible alibi witness and also some cell phone pings that were used to convict him that may or may not have any validity. And those appeals failed, and we covered why they failed. And honestly, after that, I think most people thought it was a long shot for Adnan, unless there was some DNA evidence that came back that put someone else at the scene of the crime. He probably wasn't getting out. But earlier this year, there was some DNA testing that was done, and it was a strange thing because I kept getting messages from people that would say things like, if you're going to cover, I'm saying 6 months ago, if you're going to cover Adnan, you should go ahead and do it now because he'll probably be out by the end of the year. And I thought, I don't know why you think that, but maybe you know something we don't know. Apparently they did. But a lot of it was based on this idea that they're doing this new DNA testing. And obviously, since Adnan is innocent, they're going to find other DNA. And once they do, they will file some motion to set aside his conviction. Well, it's actually interesting. There was a motion filed to set aside his conviction, but the first part of that motion talks about how they did this DNA testing, and basically none of it was usable. They didn't really find anything. They're testing a few other things, but when you read the motion, it makes you think, and they seem to believe, it is unlikely that any of the DNA testing they're doing is going to have any effect. And so you might think, well, if the DNA didn't really tell us anything, then that should be the end of it. But that is not the case. In this filing, they sort of lead with that. We did the DNA testing, we didn't find anything. But then they continue, and by they, the prosecution, the state, continues by saying, nevertheless, we think that this conviction should be vacated. And this is a huge deal. It's hard to express to you what a big deal it is for the prosecution in a case where a jury has returned a conviction, and for the last 20 years, the state has successfully argued that the person who was convicted was guilty, to do an about-face and say, never mind, this conviction should be vacated.
And the key point that Brett just said there is not that a prosecution has moved to dismiss charges or anything like that. The fact that there's been a jury verdict, there was an entire trial before a jury of his peers, and they came back with the verdict. Remember, we've talked about this before, when a judge can vacate a verdict and how limited even the judge is in that power. For the prosecution to 20 years later come and file this motion is truly astonishing. I don't think I've actually ever seen this in my work.
No, and I'll say this. Usually when you see this, it's DNA. And that's usually what it is. When you see a motion like this 20 years after a conviction, it's because DNA has definitively proved that the person who was convicted is innocent. And when you see that, you get it, obviously. Well, I mean, if they're clearly innocent, you got DNA, you have to let them go. And this is a travesty. It's an injustice. Well, what's interesting about this, there isn't DNA, and in fact, the state in the filing does not say that they believe Adnan Syed is innocent. Rather, they say there are fundamental flaws with his conviction that leads them to seek a vacation of his conviction. Now, let me read you. There is a legal standard here. Basically, All of you know that Baltimore is the most corrupt place in the world. If you don't know that, watch The Wire, which is 100% accurate based on my experience with folks from Baltimore and the legal community will tell you it's 100% accurate. And because of that, Baltimore does have a problem with false convictions. And in particular, there was one forensics unit in Baltimore that was responsible or was involved in about 3,000 convictions and was later found to be completely corrupt, completely inept. And because of that, the Maryland State Assembly passed a law allowing prosecutors to seek to have convictions vacated where the underlying investigation was so corrupt and so undermined that you could no longer stand behind that conviction. And here's what you have. It's Maryland Code Criminal Procedure 8-301.1. And it allows you to vacate a conviction in two circumstances. The first is newly discovered evidence that could not have been discovered by due diligence in time to move for a new trial that creates a substantial or significant probability that the result would have been different. That is not what Maryland relies on. If you look at their filing, they actually bold the next section, which is the state's attorney received new information after the entry of a probation before judgment or judgment of conviction that calls into question the integrity of the conviction, and the interest of justice and fairness justifies vacating the probation before judgment or conviction. So that's what we're looking at here. The state's attorney has received information that leads them to question the integrity of the conviction to the point that the interest of justice and fairness justifies, and I think really requires, the vacation of that conviction. So, what is it here that led the state to make this filing?
And before we jump into that second part that the state is relying on, typically, I mean, that's a very general, broad kind of catch-all phrase, but generally something that falls into this category of interest of justice and fairness that justifies vacating the probation is something that shocks the conscience, something that doesn't pass a smell test for anyone looking at it. It so obviously falls outside the realm of what we've accepted as a society for justice that even though it doesn't fit into the first part of newly discovered evidence, we all agree as a society it should be a vacation. So it is not a willy-nilly standard. It's actually a very high standard. It's a harder standard typically to meet than the newly discovered evidence. So keep that in mind. Even though the words are vague, they are not meant to essentially create a loophole that blows a complete hole into this criminal procedure 8-301.1. But what did Maryland rely on in this case to say that the interest of justice and fairness had to call for a vacation of the conviction? Well, the state start with a shocker. They have developed two suspects, and they tell details about them in this motion. But they won't say who the suspects are, and they won't say which information applies to which defendant to protect ongoing investigation.
Which is so strange, and I have to just stop.
Whoa.
Yeah, because once again, and the thing I think you have to keep in mind at all times here is, number one, keep in mind Hae Min Lee. She is the victim. She was murdered, and someone has been convicted for her murder by a jury. And that's sort of a big deal. And we talked about this with Maggie Freeling, our good friend who does a lot of work in innocence work and is very excited about this, I'm sure. And one of the things in our very first conversation we had with her, we talked about the duty of the prosecutor to defend the jury's verdict because no one else will. A jury has found the person guilty, and there's a responsibility as a prosecution to defend that verdict unless it's absolutely clear that it's wrong. Because our system is adversarial. And in an adversarial system, you have a judge who's independent, who can make an independent judgment. The defense comes in, they make their arguments, and then you as the prosecution, you make your arguments, and the judge decides. Here, you have a situation where the prosecution is coming into a court and saying, we think you should vacate this conviction. We have these two suspects. Big deal. We won't tell you who they are. We got some information about them. We're going to tell you the information. We won't tell you which suspect this information is about. And we won't tell you anything else because the investigation's ongoing. And you got to think that kind of, if you're the judge, might make you think, why don't you finish your investigation and then come back to me? And if you come back to me and say, we've concluded our investigation and we definitely think it's dude number one, and here's all the reasons. Here's all the evidence. Here's the physical evidence and what he said to people and everything else. And Adnan is clearly innocent. And I get it. That would take a little bit more time, and Adnan Syed would be in jail. But once again, the presumption here has to be that Adnan is guilty. He was convicted by a jury. That conviction has been upheld by multiple courts. And you have the prosecution coming in with this very vague idea of, well, there's a couple other people out there.
And here's what's crazy. We've said this in all our investigations. There are always other suspects. You do your best in narrowing down and clearing the ones that are most obvious. But just about in every case, even if you as the prosecution are like 99% sure you have the right person and well beyond reasonable doubt, there's still other possibilities. We cover this in every single one of our, prosecutors podcast cases when we go through theories that there are other potential suspects. So the fact that there are two potential other suspects is not surprising at all. I would be surprised if there were other suspects, in fact. And what Brett says there is very important. There's no timeline here for them to file this motion to vacate. I mean, they probably can't dally on information they have, but they're not dallying here. They're not even concluded in their investigation. And so you can imagine what would make a lot more sense, timing-wise, would be for them to file this motion to vacate to say what Brett just said. We, developed leads. We have now honed in and are ready to prosecute this individual and then file a charge against the new person, like in succession. So there's finality for the victim's family. Because here, we have the victim's family who are still mourning this terrible loss of their young daughter, their young sister, and thinking they've achieved some sort of justice here with the conviction from 20 years ago, and to have it ripped out from under them with no real answers as to who may have done this doesn't seem to meet the standard that is prescribed in the law.
And this is so important what Alice is saying, because so many people read this and were really excited because there are other suspects. But I want you to take a step back. Most of you are very well versed in true crime. And you know good and well that in every case, there is an alternative suspect. Every case. Think back to when we did the Yvonne Lane murder in Alliance. And Maggie did her show on that, which is so good and just such a great example of journalism. There were many alternate suspects in that case, and they all fell away. Those of you who've done deep dives into West Memphis 3 know that when the police were initially investigating, there were a lot of alternative suspects. There are alternative suspects to this day, and maybe some of them did it, but they didn't all do it. There are always alternative suspects. There are always going to be rumors. There's always going to be talk. And just imagine, what if in a month the state's like, oh, never mind, we finished our investigation and it wasn't either one of those guys. We definitively eliminated them now that we've concluded our investigation. Oops, but we vacated this conviction before we finished our investigation. Just the idea, I get it. If you're in jail and you're innocent, every day is an injustice. But on the other hand, it's been 23 years. Waiting another 6 months to get it right, particularly if you're the state. I get it. If the defense wants to go ahead and file this, fine. If the state wants to keep the defense in the loop every step of the way, and if at some point the defense is like, we have to pull the trigger because our guy's in jail and he's innocent, I totally get that. But to have the state file this in the middle of the investigation is really kind of crazy. And I don't know of any other example where the state has done something like that, particularly as we're going to discuss, when the evidence doesn't seem, at least, to be particularly strong against these other two suspects. So, what do we have here? Well, it's not so much that we just have two alternative suspects. It's that this information was available to the prosecution at the time of Adnan's initial conviction, which means suddenly Brady comes into the picture. We're going to talk a lot about Brady, but just overview, if the prosecution has information which is material and potentially exculpatory, they are supposed to turn it over to the defense. That does not mean you have to turn over everything you have. It has to be material and it has to be potentially exculpatory, but we'll talk about that in a second. What is this information they had? Well, according to this filing, the prosecution had a statement from someone, we don't know who. There's been speculation about who it is, but we don't know who it is, that one of the suspects had said that, quote, he would make Hae Min Lee disappear, he would kill her. That's obviously not a direct quote of what he said because it's in the third person, but he said something along those lines. He also supposedly had a motive, and so one witness says he told him that. Another witness says he had a motive to make Hae Min Lee disappear. We don't know who this is. We don't know who said he said this, how they knew it, whether this statement was corroborated. We don't really know anything about the statement. We have what is a hearsay statement. Now, granted, if he were charged, it would come in because it's his own statement. But that's all we know, is that some person out there said at some point that somebody else said that he would kill Hae Min Lee and he would make her disappear. That's all we know based on this filing. We also don't know what the motive is. We just know the state says they would have had a motive to kill her. We don't know how strong that motive is. We don't know how we know about that motive. All we know is that this information was available to the prosecution and it supposedly wasn't turned over to the defense. So let's talk about Brady, because what a lot of people say is, well, there was a Brady violation, so therefore Adnan didn't get a good trial and he needs to be released. Is there a Brady violation?
Didn't we do an episode on this? If only they had listened to our previous musings on Brady, perhaps.
I think we need to do a whole episode on Brady.
I think we might need to do a whole episode
on Brady? I think we need to do a whole episode.
I can't remember. We've definitely talked about Brady a lot.
I mentioned it on the other podcast because I got the case name wrong and you corrected me very meanly.
We didn't have to go into that. But well, let's tell people what Brady is, because we hear that thrown around a lot, especially in TV shows. To prevail on a Brady claim, defendants must plead and prove that 1, the prosecution suppressed evidence. 2, the evidence was favorable to the defendant either as to guilt or punishment. And 3, evidence was material to the issue of guilt or punishment. And number 3 is the one that we've highlighted in multiple areas of the law that is required, because it can't just be that every single mistake causes you to have a new trial, right? We talked about the finality of judgments and resources that go into trying these cases over and over and over again. It has to be that whatever was suppressed intentionally was material and could have changed the outcome of the trial. And the case is Brady versus Maryland. It's a U.S. Supreme Court case that came out in 1963. And in talking about Brady, the Supreme Court said that evidence is material if there is a reasonable probability sufficient to undermine the confidence in the outcome, that had the evidence been disclosed, the result of the proceeding would have been different. And that was the Supreme Court in United States versus Bagley in 1985. So about 22 years after Brady first came out.
Yeah, so once again, I think the thing people need to remember, and the thing most people don't know, it's not just the state had something and didn't tell somebody else. It has to be material. And so it has to be a level of reliability that it would undermine the confidence in the conviction. So think back to Scott Peterson. You remember we talked about all those witnesses who claimed they saw Lacey wandering around? This isn't a Brady violation because the state provided that. They provided that information. But imagine for a second they had not. Imagine they had not provided that information. Well, you may recall, even when they did provide it, the defense didn't use it. And we pointed out why. Because all of those sightings were flawed. They did things like, they did not say it was her, number one. They said it was a woman who looked like her. Most of them described her wearing clothes that she wasn't wearing. The clothes that Scott said she was wearing the night before when he saw her, but when her body was found, she was not wearing those clothes. So unless you think, and in fact, the clothes that Scott said she was wearing were found in her home. So she couldn't have been wearing those clothes and been kidnapped and been killed. So there was a good reason for the defense not to use it. Same thing with Brady. If the state hadn't turned that over and suddenly the defense had it, the argument the state could have made is, no. The reason we didn't turn it over is because we looked at it and we realized it's not material because it's so flawed. It's so flawed that it couldn't actually help the defense. And since it couldn't help the defense, we didn't have to turn it over. The thing about Brady is if you're a prosecutor and you want to be strict about this, you can keep from turning over a lot of stuff. A lot of prosecutors, and I think Alice and I were in the same place, I still am, but Alice isn't anymore. We're of the
Thanks
opinion
for pointing that out.
that you turn over everything. Just turn over everything, have open file discovery, who cares? Give it to them, and then they can never complain. And honestly, I think that's the best approach, personally. I think just give them everything, then they can't complain. Now, there's a reason you don't do that, because defense attorneys, think back to the Casey Anthony case. Defense attorneys can take things that are completely irrelevant and completely immaterial and try and blow them up into something. And then you're stuck fighting with them in court, trying to keep it out because you never really should have turned it over because it's not really material. So there's all sorts of reasons not to do that. But a lot of prosecutors, just to avoid Brady, just turn it over. In any event, you have to look at that. Was it actually material? And let's look at this information. At least all we know and all the judge knew is what was in this filing. So what do we know from this filing? The state can't even say for certain that this information was never provided to the defense.
That's crazy, by the way.
Which is crazy, right? At best, they can say that they can't find a record of turning it over. But that's not to say there wasn't a phone call that was made from prosecutor to defense. Maybe we could have had an evidentiary hearing where we called people. We called the prosecution and asked them, did you ever discuss this with the defense? Because I will tell you, sometimes you have those conversations where you talk to the defense and you say, hey, man, I got a file over here. I don't think it's material. I'm not planning on turning it over. If you really want it, we can fight it out in court. And they'll say, don't worry about it. And really, you should record that in writing. But that happens all the time.
Especially as you're getting ready for trial, because there's so much exchange of information. As you interview witnesses, you find out more information and you're not really sure if it's relevant, but you're like, well, maybe I'll just give them a call and say, hey, by the way, we had this witness. They said this thing. It sounds like a bombshell. I don't think it's anything. Do you want to explore further? This truly happens in the realities of trial prep all the time. But here's the reason, really, why there probably should have been an evidentiary hearing. It is a huge allegation to say there was a Brady violation for individuals at issue here, because this is not just unintentional, we overlooked something. This has to be an intentional trying to change the course of the case in the interest of, injustice, really. And so this is a huge, huge, huge allegation. And it is not just who knows? We don't really know if it was turned over. That is a key fact, and it's an important fact.
I mean, this is the kind of thing that gets people disbarred. If you're committing Brady violations, you're violating someone's constitutional rights. It's a huge allegation. And just to throw it out there without any support, when you don't really know, and it's been 23 years, and maybe your records are incomplete anyway. And if you doubt me about this, if you read the filing, at one point they put in a footnote and they say, well, even if it was provided, it would have been ineffective assistance of counsel not to use it. And they just throw this footnote in there. And as you guys know, who've listened to our discussions of ineffective assistance of counsel, wow, what an incorrect statement to assume an ineffective assistance of counsel claim when we know nothing about this alternative suspect. And it may have been that it was just so weak that the defense counsel was like, no, I'm not going to destroy my case, because you can imagine how this goes. You're the defense counsel and you put on evidence that somebody else did it. And the prosecution gets up and says, yeah, they were in Puerto Rico that night. They didn't do it. And you're like, oh, shoot, I look like a complete moron. And the jury's like, grasping at straws. Your client's clearly guilty. You're trying to pin it on this guy who wasn't even in the country. I mean, Puerto Rico's in the country. We'll say he's in Costa Rica. Wasn't even in the country that night, right? And there's all sorts of reasons you wouldn't do it. And that fact that they threw that footnote in there tells you something about this entire filing and how sloppy it is. And this is just the first instance where you see that. And look, we're talking about Brady. We're talking about materiality. So there are two things here. Was it turned over, and does it matter? We don't know if it was turned over, but let's assume for a second it was. Then does it matter? We've talked about this. Number one, we don't know a lot about this alternative suspect. Number two, we don't know how effective this would have been at trial. The state cites to some other cases as examples of when an alternative suspect was found to be Brady. And I just want to read you a couple of these cases so you know the difference between these and the kind of evidence we're talking about. One of the cases the state cites is Harrington versus State, which is an Iowa case, but they cite it nonetheless because Brady is Brady everywhere. So there, In that case, there were a lot, in fact, of corroborating reasons to think that the alternate suspect in Harrington really was the killer. And I want to read you from the opinion. Our conclusion, so they conclude this was a Brady violation, it should have been turned over. Our conclusion is based on two important points revealed in these reports. Gates' identification as the suspicious person seen in the area with a gun and a dog, and two, Schwerer's contact with Gates is the alternative suspect, which for the first time provided a concrete link between an alternative suspect and the victim. The state is hard-pressed to argue the defendant's trial preparation and trial strategy would not have been altered by this additional information. Officers testifying at the second PCR hearing admitted the police considered Gates to be the primary suspect based on their investigation, an investigation unknown to Harrington at the time of his criminal trial. It is fair to conclude that had Harrington's counsel been provided with this information, he would have zeroed in on Gates in his trial preparation and at trial, just as the police had zeroed in on Gates during their investigation.
So you can see how specific Harrington is, and it's not just kind of pie in the sky, there might be an alternate, but they are naming someone, and they also have specific evidence they can point to that link this other suspect to the victim. And also, this is huge, the police, who's the investigative body, actually named Gates to be the prime suspect. That is huge there. That classification is absolutely relevant to how you're going to prepare your defense. You would quite literally say, the police who investigated this, that know everything about this case, more so than any one of us in this courtroom right now, they labeled him the prime suspect. That's what I would say if I were defense counsel. And for them to hide that information, you can see how that completely offends your deep sense of justice, that the defendant in this case didn't have all available information to them to properly defend themselves.
And let's talk about process here. So in this case, in the Syed case, for those of you who don't know, Adnan Syed was released. This motion was granted. His conviction was vacated. He was released. This motion was filed, I think, on a Thursday or Friday. His conviction was vacated on a Monday. What happened in Harrington? Harrington, they had a hearing, and the police testified, and we learned about the actual suspects, and we learned about all these facts. You could feel confident in Harrington that, yes, there is a real Brady violation here. They should have known this, and if they had have known this, this would have been huge. We don't have that here. There was no evidentiary hearing in the Adnan Syed case. All we have is the bare bones filing by the state, which just sort of asserts that there's some alternative suspect. And in that filing, they cite to Faulkner versus State, which is actually a Maryland case. And I want to read you what was written in Faulkner versus State, and you tell me if this doesn't sound, at least the first part, what Faulkner wasn't versus what we have in the Adnan Syed case. This is not a case in which a petitioner has come forward with only conjecture or speculation that another person may have committed the crime for which the petitioner was convicted, which, by the way, based on the state's filing, is exactly what we have here. We have some alternative suspects. There's some conjecture. There's some speculation. There's some minor evidence. That's all we have. That's what we're basing this on. Going back to Faulkner versus State. The newly discovered palm print evidence shows, and the state does not dispute, that Ty Brooks, that's the alternative suspect, entered Mrs. Wilford's home, Mrs. Wilford is the victim, through the window that MSP initially determined was used by the burglar and murderer on January 5th, 1987. It is also undisputed that Ty Brooks had no legitimate right of access to the Wilford home. No prior break-ins was reported by Mrs. Wilford to the police. Ty Brooks has a substantial criminal history, including burglaries in the Easton areas in 1986 and 87. Indeed, he admitted to Sergeant Metzger that he terrorized Easton during this period of time. Ty Brooks falsely claimed never to have been in Miss Wilford's home, and Thomas also has a substantial criminal history going back to the 1980s, which includes armed robbery and other crimes in Talbot County. Moreover, we reasonably may assume from Ty Brooks and Thomas's invocation of their Fifth Amendment right against self-incrimination at the actual innocence hearings that had they been called as witnesses in the defense case of Smith's and Faulkner's trials, they similarly would have asserted their privilege against self-incrimination, and that the juries accordingly could have drawn adverse inferences concerning the involvement of Ty Brooks and Thomas in the Wilford burglary and murder. So it's the exact same thing Alice just talked about. You have very specific information about very specific people that lays out exactly why this was so important that the defense have it, because these are legitimate alternative suspects. I mean, in this case, you had a palm print, among other things, and you just don't have that here. You don't have a situation where the state has provided us any information. The other thing, there was an actual innocence hearing. So there was a hearing where evidence was presented, where the judge could determine that, in fact, this was the kind of evidence that you would think represents a Brady violation when you don't turn it over.
And let's talk about that a little. I know we've said process a few times, but let's just kind of give you a view into how unusual the procedure was here. Typically, every single filing within the court, even if it is unopposed to, and you usually indicate that at the top of the filing so the court knows this is an unopposed filing, and usually unopposed filings are something wrote like extension for time, extension of page numbers on your brief, those sorts of things, changing a hearing date because someone has a conflict. Typically, substantive hearings that drastically change the course of a case are not unopposed. But even if a filing like this were unopposed, a motion to vacate, almost always the court will ask for a response from everyone to make sure everyone's on the same page. Remember, there are a lot of parties at issue here. He can even hear from people who are not entered in the case if he wants to know all the equities at play here. And after those filings are all in and the judge is clear that he has the positions of all the parties and all of the entities who have an interest here, then to hold a hearing, to drill down into what each person or entity is saying. That is very typical for something of such an important movement of the case. There are some judges who have hearings about every single filing, no matter how small. And so to have such a huge change in the case with not so much as a hearing or a responsive filing or even a request by the court to set a briefing schedule for everyone is very unusual. We'll give you an example. Brett and I recently had a case with a lot of defendants. There were a lot of parties at issue, lots of lawyers, and sometimes it was like herding cats trying to get everyone's positions. For every single filing, even when we were all on a call, let's say it's like 10 different attorneys are on a conference call, and we proposed to move the dates of one of our hearings by a week. And we said it on the call, and we had already spoken with all the other counsel, and they had all told us they didn't oppose. We represented this to the court. The court then went down the line to every single counsel on the line representing each defendant and said, can you affirm that there's no opposition from your client, from your client, from your client, from your client? Even after every single one of them answered in the affirmative, no contest, no, we do not oppose that request for an extension of time, something so rote, scheduling as a hearing date. The court then issued an order making every single party write on paper and file with the court so it was on the public docket for anyone to search the position of their client. And that took a few days. It was like 48 hours. And then it took him about another day to issue the order because he wanted to make sure everyone's interests were clear on the record so that years from now, anyone who came back and looked at the record would not be confused about what happened or the positions of anyone, or that anyone's positions were accidentally left out because the ship was moving too quickly. I mean, that's just a recent example of what happened in, our case, but typically will happen in just about any court. And that's why we're kind of harping on this process issue.
And I hate to keep going back to this, but our entire system is based on the adversary process. It goes all the way back to Socrates, Socratic dialogue, just this notion, Hegel, if you like to be more of a modern philosopher, you have the thesis and the antithesis and they combine together for the synthesis, this idea that two sides arguing against each other is more likely to get to truth than really any other way of thinking about things. And those of you who don't believe that, read briefs in the Supreme Court. They're the very best people, the very best litigators, the very best lawyers operate in the Supreme Court. And take a case, find a case that's controversial, and take two briefs. Or even better, find a case about an issue you have no idea about. That's probably even better because you won't have any bias. Look for one in railroad law or something like that. Read the first brief. And when you read it, you'll be 100% convinced. You'll read that brief and be like, man, that guy, he's brilliant. That's obviously right. Then pick up the other one and read it. And you'll read that brief and you'll be like, man, no, this guy's obviously right. And then you read the other brief and you're like, man, I don't know anymore, right? Because the two arguments are so good. And when you only see them in isolation, they're so good. And you really have to think about them together and think about how they go together and where the weakness is and really who has the advantage. And that's the way you can come to some sort of truth, because the law is not black and white. It's really gray. There's a lot of really sort of difficult questions here. And you really need that. You need that sort of opposing arguments going against each other. And we don't have that. When instead you have what you have here, which is basically the state and the defense are both arguing the same thing. When you have that, it makes it much more difficult. You read it and you think, well, Brady violations.
And Brett, at the Supreme Court, to take that example further, and it happens at times where, say, the United States changes position after an administration and they no longer defend a position they previously had at the Supreme Court. Let's say one administration files a brief, and then when it's time for oral argument, the administration has changed and they change their legal position. So no longer are the entities on the two sides of the V in opposition. In that instance, the court doesn't say, well, I guess everyone's in agreement. Let's just all go home then. They actually appoint a third party to argue the side that has been abandoned by one of the entities so that there is an adversarial process. So even when the parties are no longer adverse to each other, for important cases, the Supreme Court doesn't abandon the issue if there's a live controversy for them to resolve. They actually appoint counsel to argue the abandoned issue.
And I just want to tell you guys, this is not a good brief. The brief by the state is not good. It is really weak. And if a defense counsel filed this, I do a lot of post-conviction stuff. If a defense counsel filed this in one of my cases, I would take a couple hours to write a response. I would file it, and I would never worry about it again because I would totally win. I could defeat this brief in my sleep, okay? And I'm not bragging.
I've seen you do it too.
It's just a weak argument. And we've gone through some of the reasons. I mean, this like alternative suspect stuff is so weak. And the fact they won't tell us anything, I mean, you could crush this in a response, but there is no response here because this isn't filed by the defense. It's filed by the state. And we're going to see later on one person you could have appointed the state AG. The court could have said, look, I want to hear from the state AG on this. And if the state AG comes in and says, you know what, 100% right, we need to vacate this conviction, that would be powerful. But I'm going to go ahead and give you a spoiler alert. That is not what the state AG would have said.
Let's give the people a taste of what's actually in this filing, because you got two very good cases that Brett just outlined for you, Faulkner versus state and also Harrington versus state, where we saw specific reasons that there were actual concerns about Brady violations and a difference in outcome had the defense known about those facts at the time they were preparing for trial. But what do we have here? Do we have what we had in Harrington or Faulkner? No. I mean, well, it's hard to say because the state, all they say is they have two suspects. We've talked about these two mysterious suspects, and it's actually unclear if their theory is that these two suspects work together or if they're entirely separate. Also, it's unclear whether they're related to Adnan Syed at all. The state also says that one of the suspects, again, we don't know which one, is connected to a home on the same block as where Hae Min Lee's car was found. And this information was not available to the state until 2022, so this year. Now, the state doesn't say which suspect this is, but we're going to go out on a limb and say it wasn't the one that supposedly threatened Hae. And this is why. This is the totality of this evidence. They wrote, Ms. Lee's car was found parked in a grassy lot behind the 300 block of Edgewood Avenue in Baltimore City. Through investigation of property records and other media, it has been determined the location was known to one of the suspects. A person related to the family owned a house on the 300 block of Edgewood Road for many years, and that person lived at that location in 1999. So basically, instead of a clear argument for one of the suspects, we get a parade of horribles. And real quick, a lot of people who knew Hae Min Lee probably lived on the 300 block of Edgewood because this was like the district of their school. It was within the realm of where they, lived, eat, played. The fact that someone lived on that block, there should be a lot more suspects, I should say. With that list of 3 bullet points, if that is your factor into who is a suspect, there should be many, many, many more suspects than just the 2 that they've found here.
And let me just say, the fact that they are doing this 2 suspect thing is so disingenuous, because basically, if it were one person who had all this stuff, that would be a lot more convincing. But basically, we got 2 people who we have no reason to think are connected in any way, and we're going to list the things that makes you think they might possibly be a viable suspect. We're not going to tell you which one it is. We're just going to tell you the things. And so you can sort of create in your mind the perfect suspect. I've got to say, if this person was the person who threatened her and said they were going to kill her and had a motive, they would have said that. Because if you have a motive and you threatened her and her car was found near your home, that's pretty good. But they don't say that. And let me just tell you, what are they hiding here? Like the big mystery about, well, we don't want to hurt the investigation. This person knows who they're talking about. You've just told them exactly who they are. If they were confused about the fact they're a suspect, they now know they're a suspect, right? So you're not keeping anything back by not connecting this to some of the other evidence you have. But they don't do that. Like Alice said, instead you get this parade of horribles that we're going to go through in a minute, but you don't get anything that tells you we have a concrete suspect that you should consider instead of Adnan Syed. And it's interesting because the internet is full of speculation about who these 2 people are, and neither one of them are a Don. And if you follow this, you know who Don is, because Don is everybody's favorite alternative suspect if you don't think Adnan did it. Well, according to the internet people who know more than I do about this case, neither one of these guys are that guy. So that guy apparently has just been slandered this whole time, if you believe the state's filing. So what you see here, after they've done this, we get some more stuff. This parade of horribles. We get one of the suspects attacked a woman in her car. One of the suspects abused a woman known to him. One of the suspects was improperly cleared after 2 polygraphs, and the internet has figured out that this is the person who found Hae Min Lee's body. So apparently he is one of the suspects. And by the way, once again, if the person who found the body was the person who threatened her and everything else, that would be a big deal. I don't think it's the same person. But these are such vague things. It's round up the usual suspect time, right? I can find you a lot of people in Baltimore who have committed violent crimes against women or have threatened women. I can find you a lot of people in Baltimore who knew Hae Min Lee who've done that, who lived in the area where her car was found who've done that. How is this that significant in this case? How does it tie these people to her and to her murder?
Brett, it's always fun recording right when something drops because we're like, we haven't had time to like cool down from reading the briefs. And we're just like still hot, as you guys can tell. And also you can tell by the length of this episode. But we told you that we are never going to truncate our explanation of the law to you. So that's what we're doing today. Okay, here's the really interesting turn the brief then takes. So following the evidence of the new suspects and all these parade of horribles that could have happened, but we don't know exactly by whom, then the state does an about-face and attacks its own evidence, which it has consistently and successfully, might we add, argued to the courts was reliable. This includes the cell phone evidence and the testimony of a witness. It's also critical of Jay Wilde's testimony and his reliability. Of course, none of this is new. What's new is that the state now is attacking their own evidence.
And it's so interesting to read this. I mean, because just trying to get into the psychology of this filing, the fact that, I mean, they cite to the case against Adnan Syed, the HBO documentary, which I got to think, if you're the prosecutor who has to write that sentence or you're going to cite to a pro Adnan documentary as a reason to think he's innocent, you just had to have cringed as you did that. But I mean, that's the kind of stuff they're doing. This cell phone stuff, we get it. We get it. The AT&T bill or whatever, the documents they provided says you can't rely on it for location data. If you read the filing, it's funny because they're like, we talked to this expert, and this expert, and this expert said this, and this expert said this, and were they reliable? We don't know. I mean, I'll just tell you, because I was curious, way before any of this was done, I was at a training that involved cell phone evidence, and because this is the kind of thing I do. After the training was over, I was like, hey, do you know about the Adnan Syed case? And the guy who did the training, I'm not going to say his name because I don't want him to get attacked by people online. He was like, oh, yeah. totally reliable. I know they say it wasn't, but it was totally reliable. And I was like, oh, well, that's interesting, because, and that's the fact of the matter here. If you try this case again, guess what? I can get you an expert who will say those cell phone pings put him in the park where she was buried that night. I can also get you a defense expert who will say the opposite thing. And that's how it works. And you put these two experts on, it's kind of like in the Casey Anthony case. You put two experts on, one of them falls flat, the jury gets to make a decision. What you don't generally have is the prosecution just saying, we're just going to assume that the defense side of this, that it's completely inaccurate and not usable, is what we're gonna side with.
And that's because that's not the role of the prosecution. As you've already said, it's the role of the jury. The prosecution has a job to do. So does the defense. So you can pit your experts against each other, and that's perfectly fine. You get to cross-examine each other vigorously, advocating for your client, and then the jury gets to listen to all of this and determine what they think is more credible and the likely truth.
And let me just say, the defense, all that had to happen here, and really the only thing that I wish had happened here, the state could have given the defense all this information. They could have agreed to a habeas corpus filing, Rule 32 or whatever it is in Maryland. And they could have filed a motion with the new suspects and with this stuff, and they could have hashed it out in front of a judge. This stuff is old, okay? The cell phone stuff, Jay Wilds, we know he lies. He's a drug dealer. He was selling marijuana at the time. Of course he lies. He lies all the time. That's the thing about the prosecution witnesses. When you get the guy who helped somebody bury the body, guess what? They're going to lie. They're going to minimize their position. But when he can tell you where the car is and you didn't know where the car was before, that's pretty significant. That tells you something. Maybe he knows something. And you can say, well, I'm sure that the investigator probably told him where the car was. Okay, do you have any evidence of that? Do you have any evidence that the investigator knew where the car was before Jay Wilds told him where the car was? Because if you do, that would be significant. But just saying it doesn't make it a fact. And you can point out to the jury, this guy lies all the time. He lies about this, he lies about that. But when he has concrete evidence, that's going to be pretty powerful. The people who have supported Adnan up to this point have made these arguments again and again about the cell phone, about Jay Wilds. They've done it again and again. But what you haven't seen, and what is fascinating, is to see the prosecution, after they have successfully defended this evidence for so long, just coming along and being like, we are going to now adopt the position of the defense and say all those arguments you made in the past unsuccessfully, we're now going to include in our argument to vacate the conviction. It's just mind-blowing to see it because it's not the way it typically works. Normally, you would have two sides making an argument in front of a judge, and I keep coming back to this, but normally you'd have two sides make an argument in front of a judge, and the judge, neutral arbiter, makes the decision. And when you don't have that, I really feel like you're losing something. Because who is representing Hae Min Lee here? Who is representing the victim? Who is representing the jury's decision that this person murdered her? And the answer is nobody. No one was representing her in this. No one was making the arguments for her. Even if they're bad arguments, even if they're arguments that at the end of the day should fail and Adnan should win and he should go free, they still should be made. And the fact that they weren't made, that no one stood up for her other than her family in the hearing, but it didn't matter because they didn't really have any standing to stand up for her. No one who could make a difference stood up for her in any of these hearings. And that is sad to me. And I frankly think it's an injustice.
No, I agree. There's more to say. We're trying to stick to the document to help you guys understand, what actually happened here. I just have to note one other thing. In addition to kind of adopting the defendant's arguments and saying that their evidence was not good, the state's evidence wasn't good, they go even one step further and they actually go after their own investigators, noting that one of the officers was found to have committed misconduct in another case. And there's no allegation that misconduct in the other case has been led over here. This is a very, very serious step to take because we talked about Giglio in another one of our episodes. Basically, any sort of misconduct or a finding of misconduct or untruthfulness for an officer has to be disclosed. And it's basically a mark, something that's hung around the officer's neck for their entire career and can be brought up and essentially could end their investigative career or law enforcement enforcement career if it's serious enough, because they can never be trusted on the stand. They're too easy of a target. And usually where you see these attacks come from are from the other side, saying this police officer, used excessive force and he lied on his records. His reports are always filled with falsities. And we know this to be the case. But to have your own prosecution attack your own officer or your investigator is huge, and could be career ending for the investigator, especially when there's not really an allegation here of specific misconduct in this case.
And look, what they're doing here is the one piece of evidence that is really hard for people who think Adnan Syed is innocent to get away from is the fact that they found her car, Hae Min Lee's car, because Jay Wilds told them where it was because he was with Adnan when he dumped it. That is a really hard piece of evidence for them to get around. And you have to believe that the police found her car. And rather than doing the thing that you would naturally do as the police when you find the car of a murder suspect, which is immediately go to it, surround it, impound it, get all the evidence you could because, oh my goodness, this is a huge break in the case. Rather than do that, they left it there, waited till they found somebody, I guess, they could get to finger the person they decided did it. They then forced them to say where the car was, which is information they fed to them. They fed to Jay Wilds. This is where the car is. You need to say that now. He then did that. He then never said that in the decades that followed, that he was fed that information. But you have to believe that that's what the cops did. They fed him that information, and that's how he knew it. That's the purpose of this. The purpose of this is to say this officer has some improprieties in the other case, and so therefore we can't trust Jay Wilds. He probably was fed this information. They don't even say this explicitly, but he was probably fed this information, and that's why he knew it. Because if you can't get past that, we talked about this before, like what amount of evidence do you need for a conviction? And in this case, you have Jay Wilds who says, I know he did it because I was with him. He showed me the body. We buried the body. We then dumped her car. How can I prove that? Her car's on this street. Go find it. Police find it. That's pretty powerful. I mean, forget the cell phone pings. That's pretty powerful. So they have to undermine that. And so what you have here is the state doing something that the defense has never been able to do, which undermine it by attacking their own investigator. They attack their own investigator for that purpose. Now, one thing I will ask you, and look, I've never looked into this case any deeper than listening to Serial, so who knows? Adnan may be completely innocent. I'm just giving you sort of the information that's out there. But here's a question I have for you. If you believe this is some sort of frame-up job, if the police knew what we now hear they knew, let's imagine this suspect is the suspect, that a suspect threatened her, said they were going to kill her, and the car was found near where they lived. Why wouldn't the police frame that guy? That guy seems like a good guy to frame. Why not just tell Jay Wilds, no, it wasn't that random guy, it wasn't Adnan, it was this guy, because we know he did this and this, so you need to say you're with him, and he's the one who put the car there. Why wouldn't they do that? Why are they trying to frame Adnan? What is the purpose for that? If they knew this information, which we now know they knew. I mean, I think that's something you have to ask yourself, because if they had a viable suspect, why not go after him? Now, the answer may be that it wasn't a viable suspect because of a lot of things we don't know that actually gave him an alibi or whatever, which if that's the case, then that undermines the filing on the other end because it makes it seem like this is not a viable suspect, therefore it's not a Brady violation. So those are just things to think about when you're thinking about whether or not all of this that happened made sense. Now, here's a question for you. So the state filed this, and some people said this. My initial thought when the state filed this was the court will appoint someone. You know, my initial thought was there's no way the court, without a hearing, is going to just release this person who's been in jail for 23 years and had a jury verdict against them. I was wrong about that. They just released them. They didn't appoint anybody. They didn't ask for the attorney general's position. Did they have to do that? The answer is no. Just because the state filed something doesn't mean the state wins. There was a case in 2021 which looked into this and said the court was right that the mere filing of a 8301.1 motion is not a guarantee that the conviction will be vacated. The language of the statute is permissive. The court may vacate the conviction even if it makes the necessary findings. So the court didn't have to do this. The court could have taken upon itself the responsibility that the prosecution had laid aside, which is to represent the victim and the victim's interest and the interest of a jury verdict before vacating a conviction. It is just, and we've tried to do this, and I don't know if we've succeeded. It is difficult. It is difficult to overstate what a big deal it is to set aside a jury's conviction. It just doesn't happen that often. The standards are really high in every case, every single case that ever happens. The jury convicts, the jury leaves, the judge says to the defense, "Do you have any motions?" The defense makes a motion for a judgment notwithstanding the verdict, and they lose because the standard is so high to win that motion. But here you had, in a weekend, a judge deciding based on a bare bones motion to vacate a conviction which has been upheld again and again and again by Maryland's courts, and without so much as an argument from an opposing side to say why the judge shouldn't do it.
So in other words, there were two stages to this, both of them where I think the people who had to abide by the law kind of did not go through the typical procedures here. And that's a really great point, Brett, because usually, if the state is seeking to vacate, you would think, oh, of course, they're the ones who are charging. Of course, you would grant it. But the court specifically addressed this issue and found that was not necessary, just in case there was a situation where the state abandoned a very important conviction like they have in this case.
Yeah. I mean, look, you're not going to find anything like this anywhere in the country. I mean, this is unique, and it's so interesting because one of the things you have to believe if you think this is a justified thing, and the reason that usually this follows DNA is powerful evidence. Everybody knows that. If you have a murder case or rape case and you test the DNA and it comes up with somebody else who is not the killer or the rapist, and in fact is someone else who also was a rapist or a killer, that's really, really powerful. And whatever you had before, an eyewitness or, some cell phone data or even a jailhouse informant or whatever you had before pales in comparison to that. So normally you have that and you're like, okay, fine, we got to vacate this conviction. This is an unjust conviction. But this is nothing like that. And I just want to point out once again, one of the things about Brady is in order for it to be a Brady violation, it has to be material. It has to be something that would overcome all the other evidence. That is the same standard, by the way, as ineffective assistance of counsel. We talked about ineffective assistance of counsel, and we talked about it specifically as it relates to the Adnan Syed case. I think it's worth noting that in 2019, not 2002, or 1999. In 2019, a court considered this very question about whether or not a ineffective assistance of counsel claim in which they found ineffective assistance of counsel. That's what's crazy about this. They found that the counsel was ineffective for not putting on the alibi witness, the witness that so many of you think is so powerful, Asia McClain. They found she should have put her on, and the fact that she didn't is ineffective assistance of counsel. But there's a second prong, prejudice. You have to show that had you done that, it would have overcome the other evidence. And what I see so much is people saying, there's no evidence that Adnan did it. There's no evidence that Adnan did it. No idea how he got convicted. It was just like crazy randomness, right? But in this 2019 case, the court goes through a lengthy discussion where they lay out the evidence. You should read the whole thing. We will post it online because it'll be easier if we post it online. State versus Syed, 463, Maryland 60, 2019 is the case. There's a lengthy discussion of the evidence, but they sum it all up in a paragraph. And so I'm going to read you the paragraph just so you know this was the evidence that in 2019 was good enough for a Maryland appellate court to say, even though you were ineffective for not putting this on, it wasn't prejudicial because of all this evidence, which would be the same analysis that would be done to any supposed Brady violation. So I'm just going to read this to you. With that in mind, we highlight some of the more crucial evidence the state relied on to prove its case. Mr. Wilds testified that Mr. Syed had complained of Mrs. Lee's treatment of him and said that he intended to kill that bitch. Mr. Wilds claimed to have seen the body of Mrs. Lee in the trunk of her car at the Best Buy parking lot. Ms. Pusateri, a friend of Mr. Wilds, told police and testified at trial consistent with those statements that Mr. Wilds told her that Mrs. Lee had been strangled. At the time Mrs. Pusateri relayed this information to the police, the manner of Mrs. Lee's death had not been publicly released. Mr. Syed's cell phone records showed him receiving a call in the vicinity of Lincoln Park at the time that Mr. Wilds claimed he and Mr. Syed were there to bury Mrs. Lee's body. Mr. Wilds directed the police to the location of Mrs. Lee's abandoned vehicle, which law enforcement had been unable to find for weeks. Mr. Syed's palm print was found on the back cover of a map book that was found inside Mrs. Lee's car. The map showing the location of Lincoln Park had been removed from the map book. Various witnesses, including Mrs. Pusateri, Nisha Tana, and Christina Vinson, testified to either seeing or speaking by cell phone with Mr. Wilds and Mr. Syed together at various times throughout the afternoon and evening on January 13th, 1999. Given the totality of the evidence the jury heard, we conclude there is not a significant or substantial possibility that the verdict would have been different had trial counsel presented Mrs. McLean as an alibi witness. And I think you could apply that same evidence to whether or not the things that you have heard from the state's filing would have resulted in a different verdict from the jury.
And this is the interesting thing. This is a very strong statement by the court in 2019 that the state's new filing to vacate the conviction makes no attempt to try to explain why this conclusion in 2019 is now changed because of this additional evidence. That you would think that would be a hurdle they would have to cross, that this court, who vacated the conviction, would have been interested in knowing why this 2019 opinion should essentially be overturned, especially after they already found that there was ineffective assistance of counsel, but it didn't matter. It didn't hit the prejudice prong, and nothing in the latest motion by the state to vacate the conviction indicates that there is prejudice.
And I just want to say, I love you guys. I really do. And I love your faith in the system because I have a lot of faith in the system. But there are a lot of people out there who said things like, well, this is good because now they can have a new trial without these Brady violations, without all these problems. And then we can really find the truth. There's never going to be another trial. There's not going to be another trial of Adnan Syed. And these two suspects will never be tried. Number one, when it comes to Adnan, imagine if after this investigation concludes, the state's attorney's like, oh, you know what? He really did do it. And Jay Wilds, he was telling the truth the whole time. Imagine walking into court if you're the defense attorney and you're like, this is going to be fun because the state's going to tell you to listen to Jay Wilds. Well, here's their own filing. Here's where they say he's a liar. Here's where they say that their own investigator is corrupt. Here's where they lay out all the reasons you shouldn't suspect it's Adnan Syed.
I mean, the defense would just have to read the state's motion as their playbook. They don't even have to do any prep for trial. They literally just read back to the jury everything the state has said in their own filings. I mean, they literally have a playbook from the state.
Yes. The state is going to dismiss this case. I get it. You know, right now it's still up in the air when the new trial is going to be. Within 30 days, the state, they will null pros this, which is sort of the technical term for they're not going to prosecute it. And this indictment will be dismissed and Adnan Syed will be a free man. He may or may not sue. I don't know if he'll win or not. There's some good arguments for the state. They'll probably end up settling. He'll probably get some money for the time he spent in jail, but nothing's ever going to come of this. I mean, Marilyn Mosby and OJ are not going to be riding around Baltimore looking for the real killer. This is over. They're not going to prosecute these new people. Imagine, look, unless they find a videotape of one of these new people doing it or suddenly some magical DNA appears, it's very easy, even if they prosecute one of these people. How hard is it going to be? You know, witness number one for the defense is going to be Jay Wilds, who's going to get on the stand and say, it wasn't that guy, it was Adnan, and I know that because I was with him. It's all laid out for them. This is an utter disaster. And the people online who are like, now we have to find justice for Hae Min Lee, there's not going to be any justice for Hae Min Lee. The best you can say is if you think Adnan did it, he served 23 years in prison, which is, and I said this on Facebook, and I think people took it the wrong way. I'm just saying, if you think he did it, He served 23 years. That's a long time. And frankly, it's a long time for a murder, particularly a murder committed when you're in high school. There's a lot of people who are not going to serve that much time. We can debate whether that's a good thing or a bad thing, but if you think he did it, you should take comfort in the fact that he served a lot of time for it. And there's some justice there. And I get it. This whole thing is a mess, and I could understand be upset by that, but he served a lot of time. Obviously, if you think he's innocent, you should be happy that he was released. But there's something for everybody here. But I think at the end of the day, the only person who was never represented and whose interests weren't considered was Hae Min Lee. Her family found out a couple days before they filed this. I mean, that's one of the great, and I just go back to this. I get it. Like I said, one day in prison when you're innocent is an injustice, but we couldn't have done the family the dignity of giving them a little bit more heads up that you're going to file a motion to vacate the conviction of someone that for 20 years you have told them killed your daughter. And they released a statement that was very much along those lines. It was basically like, you've been telling us for 20 years that this was the guy, and then 2 days ago you tell us he's not, and now he's free. Like, how are we supposed to feel? But nobody considered them, and nobody represented them in all this process.
Yeah, and here's an interesting kind of, I don't think it's going to be really the coda, because I think there's more to come. I agree with you, Brett. There's not going to be a new trial for all the reasons you stated. But here's very interesting. We've been talking about the state, but it's really not the state, because there's the Maryland Attorney General, and they issued a statement after the motion to vacate was granted. And they said, among the other serious problems with the motion to vacate, the allegations related to Brady violations are incorrect. Neither State's Attorney Mosby nor anyone from her office bothered to consult with either the Assistant State's Attorney who prosecuted the case or with anyone in my office regarding these alleged violations. The file in this case was made available on several occasions to the defense. So clearly here, the Attorney General would have defended the conviction and would not have allowed this motion to vacate to be filed if they had known in advance of the filing. And that's a big deal here. But again, the judge didn't take the time to ask for the opinion of the Attorney General or to really allow any time. There was really not even a business day in between the filing and the granting of the motion to allow parties who needed to be heard to be heard.
And I think it's easy in this case to let emotion get in the way. There's a lot of people who feel very passionately that Adnan Syed is innocent. And I totally get that, and I totally understand while today is a good day for you. But, take yourself out of that. Imagine this is not a famous case. Imagine it's one of your relatives who has been murdered and there's been a conviction, and for 20 years that conviction has stood, and suddenly this random state's attorney decides on a lark, we are going to file this motion, and then it's over. This conviction's just gone, and there's no recourse, there's no review, there's no one to represent you. And look, I don't know that it had anything to do with it, but you can't look at this case and not realize that Mosby has been indicted by a federal grand jury and will soon be facing a trial for various crimes. I don't know that had anything to do with it, but once again, do you put all your faith in that person? Do you assume that person made a good decision? Don't you wish there was some recourse, someone to review this? And I just got to say, guys, if you're in Maryland, you should really want to change this law. There should be, I get why they passed it. I get the issue it was intended to address, but y'all need a little bit more process in this before somebody can just decide, I am going to say this should be vacated, and therefore it will be vacated. There needs to be more. People have asked us what sort of precedent this is set. I don't think it sets any precedent because this is Maryland and Maryland law, and it's a very specific Maryland law that I think was probably passed a little too quickly without enough consideration about the consequences. And so that's what you have here. And it would have been nice if anybody had represented the Lee family and had represented Hae Min Lee and had represented the jury's verdict. I think it would have been nice if someone had stood up in that courtroom with authority, not just the lawyer for the family, but someone with authority, and said, Your Honor, you should deny this for these reasons. And you didn't have that. And so what you got was a rubber stamp decision that maybe you think it's the right one, but it concerns me. The process concerns me. The lack of any argument on the other side concerns me, and it concerns me what this means if you live in Maryland.
Indeed. Okay, so we have said, we beat the drum on several things many times here, but we hope that we have made sense of really a long saga. This really goes back to, I think, when Serial came out in 2014. This has been kind of in the news for almost 8 years now, and a lot happened very quickly when a lot didn't happen for 23 years. And so we hope we've shed some light on what has happened, what the state's filing means, what this means going forward, what will happen to Adnan, which I think is that he'll now just be a free man. And to keep all these things in mind, because I think what Brett said earlier is probably the most important takeaway here. Don't forget Hae Min Lee. At the end of the day, she is still not vindicated today, whatever the truth is. And the ramifications this is going to have on the rest of her family and those who loved and knew her is going to go well beyond Adnan's name in the headlines. And these are important things to consider, victims' rights and finality, when thinking about these sorts of cases as well. So that was a lot, and we hope you've enjoyed it. And let us know what you think. And if you disagree with us, that's fine. If you don't understand something that we talked about within the filing or within the law, we are always happy to try and shed some more light on that. But before we sign off for today, Brett, do you have any additional comments?
I think I've probably said enough. I mean,
More
look,
than once, but we love you for that, Brett.
I don't know. And so many of y'all want us to cover this in depth, and I just don't know if there's any purpose.
Now there's no
so
purpose,
much.
for sure.
Yeah, I mean, nobody's going to change their mind on this. And I don't know if he did it or if he didn't do it, but we've told you the evidence that at least the courts thought was significant. And I just really wish that people had as much. Well, number one, I'll say this. I feel bad for Temujin Kinsu tonight because that dude is 100% innocent and he's sitting up in prison in Michigan and nobody cares about him. And it would be nice if he had as much of a media push as Adnan had. And if you don't think the media push had anything to do with this, I'm just going to have to disagree with you on that.
There's a
Because
reason it happened now, not 23
Yeah.
years ago.
Yeah, exactly. And Temujin's been in jail for 10 years longer for a crime that I'm sorry, I do not think he committed, and I don't think there's any evidence he committed. And it's just unfortunate that again and again he has failed by the people, not the people of Michigan, but the people in Michigan who have an opportunity to do something about him. And I just kept thinking about him as this happened. So that's the first thing. But the second thing is, this is a case where a young lady was brutally murdered, and I just wish there was as much focus on her as there is on Adnan Syed. And maybe he's innocent and maybe he's not. But what I know for certain is tonight, the person who killed her is not being held accountable for that. And that, to me, is an injustice.
Well said, Brett. And I'll just end with this. Hae Min Lee's brother, Young Lee, spoke today. And after this motion was granted, he said, "This is not a podcast for me. This is real life." And I think it's really important for all of us to remember this. Obviously, you're listening to a podcast now, but these are real people that we're talking about, and it matters. So we should not, make these decisions quickly and without thought. And that's why we've given you almost an hour and a half podcast today to try and make sense of it. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
That one.
Child
Apples
song.
and bananas. I love it. It's my favorite one.
Is
And then
there
when they do
anything
the long ooh sound, it's like,
in
I
particular
like
you love
to
about it?
oot.
Or have you lost it? What's going on?
Ooples and
Are you having a stroke as we
bananas.
record? Should I be worried? Should I call
I
someone?
just love the ooples and banoonies. I love it. It's my favorite one.
You and every child under the age of 4 love that song
Yeah,
too.
it's a great song.
What's going on?
When
Does
we're
this tie
like-
into what we're recording today?
When we're listening to kids songs, when that one comes on, I'm like, this is my jam. I love this
This
one.
is my jam.
Yeah.